I'm Dr. Kalpana. In this lecture, we would be dealing with certain concepts which are provided under Industrial Dispute Act. Protection from layoff, retrenchment, closure. Uh, that's a very short and crisp lecture because these terms are important. What does they mean and what is the provision? So coming to concept of layoff and what is the compensation for layoff? Many of you might be understanding what is layoff. During COVID, a lot of layoffs happened. So definition of layoff that has been defined under Section 2 Triple K of Industrial Dispute Act. Layoff means failure, refusal, inability of an employer to give employment to a workman whose name is on the muster roll of industrial establishment due to shortage of coal, power, raw materials, accumulation of stocks, breakdown of machinery, and natural calamity. That has happened recently during COVID, where people were not able to retain their employees and workmen, and lot of layoff happened. That is layoff. I believe majority of you must have heard this term in newspaper and through media. Now coming to what are the essentials of layoff. Workman must be on the muster roll as per section 2 triple K. He must not have been retrenched. In next slide, I would be dealing with retrenchment. There must be a failure or inability to give employment on the part of employer. The reasons must be bona fide, shortage for raw material, power, etc. Now coming to in case of layoff, what is the provision of compensation to that workmen? So eligible workers are entitled under section 25C 50% of basic wages and DA, dearness allowance for layoff days excluding weekly holidays applicable to industrial establishment with 50 or more workers, only to workmen not supervisory, managerial employees, excludes badly and casual workers. Regular workers must be there. Exceptions: no compensation when worker refuses alternative employment in the same establishment. Worker does not report for duty when called. The layoff is due to strike or slowdown by workers. There is a case, workmen of Diwan Tea Estate versus Diwan Tea Estate 1964, explained layoff and associated compensation rights. Now coming to the concept of what is retrenchment and rights of retrenched workmen. Definition has been provided under section 200. So retrenchment means termination of service of a workman by employer for any reason other than punishment by way of disciplinary action, voluntary retirement, retirement on reaching the age of superannuation, termination due to continued ill health, non-renewal of the contract. These conditions should not be there. Then only retrenchment is a termination of the services. Any reason other than that. So now coming to what are the conditions for valid retrenchment that has been provided under section 25F. Before retrenching a workman employed for 1 year plus, the employer must give 1 month notice or wages in lieu thereof. Pay retrenchment compensation 15 days, average pay for every completed year of service. Notify the appropriate government. Principle of last come, first go. That is very important uh, principle which has been provided under section 25G. Retrenchment should be in reverse order of seniority unless reasons are recorded to contrary. Last come means the person who came at last and first go. Last come, first go. Re-employment of retrenched workmen is provided under Section 25F. Before retrenching a workman employed for 1+ year, the employer must give 1 month notice. Principal retrenchment, re-employment of retrenched workmen, which is provided under Section 25H. So you need to remember 25FGH in sequence. Retrenched workers have preference in re-employment if employer hires again within a year. State Bank of India versus N. Sundaramani. Termination even on contractual expiry was considered retrenchment unless excluded under Section 200. Now coming to the third concept of this lecture, concept of closure and limitations on closure. Definition of closure has been provided under Section 2CC. Closure means permanent closing down of a place of employment or part thereof. Procedure for closure has been provided under Section 25 FFF. In establishment employing 50 or more workmen, employer must give 60 days prior notice to appropriate government. Pay compensation equivalent to retrenchment compensation, that is 15 days average pay per day year of service. Closure in Chapter 5 of Establishment, 100 plus workers, Section 25O requires prior permission from the government when it comes to an establishment is having 100 plus workers, because it's a matter of 100 plus workers, requires prior permission from the government. Government can refuse permission if it is not in public interest. Permission is deemed granted if not responded within 60 days. There are some exceptions: natural calamities, illegal strikes, when it comes to closure. So, Excelsior versus Union of India, Supreme Court held that right to close business is a fundamental right under Article 119G, but can be reasonably restricted in public interest. Special permissions under Chapter 5B, debate on labor flexibility. Chapter 5B, applicability applies to industrial establishment with 100 plus workers. Covers layoff, Section 25M, retrenchment, Section 25N, and closure under Section 25O. Special permission from appropriate government is mandatory before action. Purpose of Chapter 5B to protect large-scale employment and ensure government oversight on mass dismissals, reflects pro-labor welfare orientation of the law. So key provisions are Section 25M, prior permission needed for layoff; Section 25N, prior notice plus permission needed for retrenchment; Section 250, prior permission for closure. Labor flexibility debate, employers' argument, stringent requirements discourages investment and hiring. Labor rigidity hampers productivity and competitiveness. Workers' argument, flexibility often leads to job insecurity, contractualization, and dilution of welfare. Importance of decent work, job protection, and collective bargaining rights. So reforms and contemporary developments. Industrial Relation Code 2020 raised threshold for Chapter 5B applicability from 100 to 300 workers. Easier exit for employers, focus on ease of doing business. Critics argue that it weakens worker protections. Now, to conclude this lecture, the provisions of layoff, retrenchment, closure under Industrial Dispute Act 1947 are aimed at balancing industrial development, worker security. Evolving debate on labor flexibility versus job security continues to shape India's labor policies, especially under new labor codes. With this, I would end here. Happy learning.